Hello everyone, welcome back to the channel Radheshyam Legal. In today's lecture, we are going to understand sections 1 to 8 of the Civil Procedure Code 1908. These are the preliminary provisions which appear very starting of the BIR Act. We all know CPC is the backbone of civil litigation in India. If you want to practice in civil courts, these sections are extremely important. Let us begin. Now, we have an overview of sections from 1 to 8, which are basically divided into three parts for easy understanding. Sections 1 to 3 says application and definitions. Sections 4 to 6 says about court trials and jurisdiction. Sections 7 to 8 says about local and jurisdiction limits. Now, let's start with section 1, that is short title, extent, and commencement. Section 1 answers three basic questions. First one is, what is the name of the act? Where does it apply? When did it come into force? Now we'll see the first one, that is short title, the name of the act. It is also called as the Code of Civil Procedure 1908. It is the name given to the act. It is an Act 5 of 1908 which is enacted on March 21st, 1908. And the second one is, where does it apply? It extends to the whole of India except the state of Nagaland and the tribal areas, certain tribal areas. Previously, Jammu and Kashmir also used to be under exception, but not now. After Jammu and Kashmir Reorganization Act 2019, it was removed. Now, the extent of CPC is whole of India except the state of Nagaland and the tribal areas. And the third answer, when did it come into force? Though it enacted on March 21st, 1908, it came into force much later on 1st January 1909. Here you have to remember some key points, which is it is a procedural law. CPC is procedural law. We all know that it is not a substantive law. That means it does not create rights. It only provides the procedure to enforce civil rights. So remember, substantive law gives rights, procedural law provides the method to enforce them. And also, it is CPC had pan India application with only limited exceptions. And also, it is one of the oldest continuing laws. Even CRPC is changed to the new act, but CPC we are continuing the oldest laws, and this CPC is amended multiple times to modernize. Now, section 2, that is definitions. Even though in BEAR Act we have approx 20 definitions, but we'll see only important terms defined in the code. First, we'll start with the degree. Degree is the formal expression of an adjudication which conclusively determines the rights of the parties. Here, the important point is a degree decides the rights finally. For example, if the court declares that A is the owner of the property and not B, that is a degree. A is the owner of the property, that is a degree decided by the court finally. And next is a judgment. A judgment is the statement given by the judge explaining the grounds of a decree or order. So, judgment is a reasoning. Decree is a final decision given by the judge. Third one, we'll see order. An order is the formal expression of any decision of a civil court which is not a decree. For example, granting adjournment, allowing amendment, or granting temporary injunction, like that. Next, we'll see pleading. Pleading means plaint or written statement. Plaint is filed by the plaintiff. We all know that about plaint. And written statement is filed by the defendant. We also know that. Here, no evidence and no material facts. Pleading means only plaint or written statement comes under the pleading. And the next is foreign judgment. A judgment delivered by a court not established in India is called a foreign judgment, because judgment delivered by a court that is not established in India. Next one is legal representative. A person who represents the estate of a deceased person. Here, estate means the total assets or liabilities related to a deceased person. Deceased means a dead person. This is important in case of death of parties during a suit. Now, section 3, subordination of courts. Section 3 explains and establishes administrative and judicial hierarchy of civil courts. Here, for purposes of this court, the district court is subordinate to the high court, and every civil court of a grade inferior to that of district court, and every court of small cause is subordinate to the district court, which means here district court is subordinate to the high court and subordinate courts are under the district court. First, highest court is what? Supreme Court. Then High Court. Then District Court. Here, under District Court, we have subordinate courts and also courts of small causes. Why this is very important? Because appeals and revisions follow this hierarchy. Here, remember, always remember, appeals move upward in this structure. It will start from the lowest of the court and moves upward in direction to the highest court. Next, section 4, trials to be conducted by courts. This says all civil suits shall be instituted, heard, and disposed of by civil courts established under law, which means only civil courts should institute, hear, and dispute all the civil suits. Here we have three implications. First one is judicial monopoly, means only courts can try civil suits and not administrative bodies or tribunals unless specifically authorized. No private arbitration default. Parties cannot bypass courts without specific agreement or statutory provision. Next, establishes court authority. Courts have exclusive jurisdiction to adjudicate civil disputes. Next, section 5, saving of inherent powers. This is a very powerful provision. It says, nothing in this code shall limit the inherent powers of the court to make orders necessary for ends of justice or to prevent abuse of process. We'll see key aspects of these inherent powers. First one, supplement the code. Court can act where the code is silent. Means even though CPC does not specifically provide something, court can still act. Second, ensure justice. These inherent powers can be exercised only for ends of justice. Third one, prevent abuse. For example, if someone is misusing court process just to harass the other party, court can intervene using inherent powers. Fourth one, not arbitrary, must be exercised judicially and sparingly. Next, section 6, pecuniary jurisdiction, which means jurisdiction based on the monetary value of the suit. Different courts have different monetary limits. We'll see when this pecuniary jurisdiction will apply. State government establishes courts of different grades. Each court has specific monetary limits. See, this limit varies state to state. For example, suit below 3 lakhs may go to the subordinate court. Suit above 3 lakhs may go to the district court. It determined by the value of subject matter, and it is very important because if you file a suit in the wrong court due to the valuation mistake, it may be returned. So it is very important to always check the value of the suit and also court's pecuniary limits. It is used for the efficient case distribution, and also it reduces the burden on higher courts. It ensures appropriate resources for the case value. Always remember, filing suit in wrong court can lead to the next section 7, provincial insolvency jurisdiction. This section 7 preserves the jurisdiction that courts exercised before the commencement of CPC in insolvency matters. Understanding the provision in easy way in terms of historical context, insolvency matters were governed by provincial insolvency acts. Today, insolvency law is mainly governed by the Insolvency and Bankruptcy Code 2016, that is IBC 2016. So, Section 7 has very limited practical relevance today. Coming to the scope, it is very limited practical relevance today, and the current status of this provision is it's IBC 2016 is the primary law. Section 7 has very limited application. It has only the historical significance, but academically it is important. Next, section 8. This section 8 tells us every suit shall be instituted in the court of the lowest grade competent to try it. We have seen in section 6 and also section 7. Along with that, we have to remember every suit shall be instituted in the court of the lowest grade competent to try it. The core principle for this is to reduce the burden on the higher courts and also for the efficient judicial administration and also proper distribution of cases. To see the practical application of this, for example, if we see, if a suit is worth 2 lakhs, file it in subordinate court, not in the district court. And this also subject to the two exceptions, exception under section 6, which determines the pecuniary jurisdiction that determines the court, and also the second exception under section 7, insolvency matters follow specific rules. This section 8 is subjected to section 6 and also section 7. Next, we have a summary of sections from 1 to 8. Remember these sections from 1 to 8. First one is title, extent, commencement. Section 2 defines definitions, key definitions. Section 3 court hierarchy and subordination. Section 4 only courts can try civil suits. Section 5 inherent powers of courts. Section 6 pecuniary jurisdiction. Section 7 provincial insolvency jurisdiction. Section 8 suit in lowest competent court. Thank you everyone. Bye.